Hey everybody, hopefully you can hear me. I haven't streamed in a little while. Oh, can you hear me? I haven't streamed in a little while. Here already? Aaron with a cat. Oh, can you hear me? I haven't streamed in a little while. Here already? And original cat. Aaron with I gotta put the chat thing on here. I haven't done this in a while. This is all new to me. Keisha is catering, and I'm catering to everybody's needs and expectations. Okay. Hold on a second. Yeah, my thing like cut out for a second. Okay, yeah. All right. Okay, cool. Ooh, let me put the chat thing up here. I hope. Ooh, look at that. Okay, that'll have to do. Hey, everybody. So yeah, I'm gonna start with this Melly thing. It's only like 4 pages or 5 pages, just to give people a second to get here before I go on a rant for several hours because I'm in a bad mood today. Well, I'm actually in a good mood and a bad mood. I don't know. It's complicated. Hey, Matthew. Everybody's saying hello to each other. It's like a little community we have here. Okay, so I'm just gonna get right into this. I haven't read this yet, so hopefully it is. Well, I know the outcome, but hopefully it's well written, so I don't have to freak out before it's time to freak out. But yeah, I'm gonna go through some of the Mounk Tounk stuff. I'm not sure what yet. I'm probably gonna go through the 2018 guilty plea because it's of how messed up it is, and I don't think anyone's talked about it yet, and it's really stupid. And I think I'll probably look at some of the. Ooh, I need to update this. Gonna go over maybe the revocation hearing and just do a little breakdown of that, especially now that the states admitted that they lied about virtually everything. What does this button do? Start a Q&A. How does that work? What? Okay, we're ending Q&A. Going back to live chat. I didn't understand how that worked. I sound like Dee Dee from Dexter's Lab. Hold on. I don't know what that means, so I gotta listen to myself for a second. I sound like Dee Dee from Dexter's Lab. Hold on. I don't know what that means. Rant on HomePods. Okay. All right. So yeah, I'm just gonna read through this right quick. I don't know how to say this name yet, but I need to because she's my hero. What does this button do? That's basically what OBS is to me. There's way too many buttons. Okay. All right. I'm going to get started. The state appeals order suppressing evidence in 2 trial court cases involving Jamal Demons, a double murder case, and a related witness tampering case. Okay. The trial court deemed search warrants associated with digital storage and social media platforms to be overbroad. As I recall, they went back to the beginning of the account creation rather than just the time necessary, the relevant time period. Consistent with the affidavits filed in support of the warrant, the trial court severed the warrant's impermissible portions and temporarily limited the warrant scope to the date or hours before the murder to pinpoint his location around the time of the murders. That makes sense. They're not letting the state bring in like everything dating back several years to the creation of the social media accounts in question. So it's very reasonable. In its appeal, the state does not defend the propriety of the individual warrants. Way to stand on business, state. Rather, the state argues that all evidence recovered from the warrant's execution would have been inevitably discovered or obtained from independent sources. They love their harmless error stuff. Yeah, Kels, it's ridiculous. Let me see. Demons filed a cross appeal to challenge the omnibus order. Demons argues that Florida law does not permit severance of constitutionally infirm general warrants, so all evidence associated with those warrants should have been suppressed and not temporarily limited. See, okay, this is why you don't do, Matthew's going to appreciate this. This is why you don't do justified alignment, because what is this? Justified alignment needs to go. I don't know who who started this. Like, why it's more important to have these lines here than it is to just, have the spacing look right. My goodness. Oh, wait, you guys can't even see this, can you? There we go. That's better. My first ever interaction with Max was explaining to him why justified alignment is bad. That was the first time we ever spoke. I was just the psychotic guy talking about justified alignment on Twitter. Yeah. He said that he only used justified alignment because fancy people use justified alignment. And I get it. I really do. Okay. Let me see. We affirm the trial court's order regarding the independent source inevitable discovery arguments. The trial court was entitled to reject the testimony of the state's primary witness as rank speculation. I believe that was Polo. We write primarily to discuss our reasons for rejecting Dem's criticisms of the trial court's narrowing of the warrant scope. So they're not even spending a ton of time. Oh, yeah, Matthew, that's right. I need to look at that one. That was really funny. I also like that style guide. I was looking for it before you reminded me of which circuit it was. I knew there was one appellate court circuit that had a guide like that, but I couldn't remember which one. So yeah, they're not even really spending time discussing the state's position. They're really just discussing the more interesting question, which is Demon's argument. He's arguing that the entire thing needs to be thrown out. They can't just throw out bits and pieces. We primarily discussed our reasons for rejecting Demon's criticisms. That's actually incredibly savage, really. We're not going to spend our time addressing the state's argument because it doesn't merit it, but we'll spend time on the other one. Mary James. Let me see. Demons argues that proportionality must be considered with any severing of a warrant. A court must consider the relative size of the valid and invalid portions of the warrant, and severance is not appropriate where only a relatively insignificant portion of the warrant is valid. That makes sense. If you make like one mistake and you accidentally bring in like one thing that's inappropriate and you have 1,000 things that are appropriate, I can understand that. But obviously, if you have one thing that's appropriate and 1,000 that are inappropriate, that would be different. Oh, Mary, hope you feel better. The trial court noted that Florida and some federal courts have agreed that a warrant's partial invalidity does not necessarily render the entire warrant invalid. The trial court found general support in Florida for partial suppression severability, but no guidance about how to sever. 3, Johnson v. State. American jurisdictions are in general agreement that partial invalidity does not in itself render the remainder invalid. Yeah, just going back. 1987. Seems like it's pretty unanimous that severability is okay, but how to do it is trickier. Hey, YP. The trial court's omnibus order noted the limitations on severability when the challenge provisions are invalid due to lack of probable cause. The order recognized that federal courts have severed when the challenge provision is overly broad due to a failure to include a reasonable limitation. Okay. Yeah, true, Aaron. The court should instead sever the infirm portion of a warrant from the remainder, which passes constitutional muster. That's interesting. Interesting distinction, but it makes sense. So you need probable cause. If you have probable cause, then you can sever. Upon considering federal cases, the trial court applied the Second Circuit's approach. That's like New York. As detailed in Galpin, which adopted that of Sells Galpin? Oh, of Sells. I'm stupid. Those are separate things. We approved the trial court's reliance on Galpin to narrow the warrant's time frame. Notably, Galpin's approach accounts for proportionality. As a caution, the severance is not an available remedy for an overbroad warrant where no part of the warrant is sufficiently particularized, where no portion of the warrant may be meaningfully severed, or where the sufficiently particularized portions make up only an insignificant or tangential part of the warrant. Galpin reviewed an order denying suppression of, not going to read that because, I'm monetized now, recovered pursuant to a search warrant for physical property and electronic equipment. The defendant previously had been ordered to register as an offender and abide by related terms. The defendant argued the warrant was overbroad as the warrant had authorized a search for evidence of unspecified crimes and images, despite the only specified crime being the defendant's failure to register an ISP account or communication identity. In considering severability, Galpin looked to the 10th Circuit step-by-step methodology, safe words only. True. Let me see. First, the court must separate the warrant into constituent classes. Second, the court must examine each individual clause to determine whether it is sufficiently particularized, supported by probable cause. Third, the court must determine whether the valid parts are distinguishable from the non-valid parts. Severability applies. Some part of the warrant must be both constitutionally valid and distinguishable from the invalid portions. Contrast, redactions inappropriate when the valid portions of the warrant may not be meaningfully severable from the warrant as a whole. That makes sense. If there's part of the warrant that stands on its own, it's okay. And if there isn't, then it is not. Got to conclude the court must be able to excise from the warrant those clauses that fail the particularity probable cause requirement and in a manner that leaves behind a coherent, constitutionally compliant redacted warrant. This kind of reminds me of Sledge, actually. Galpin cautioned that even where parts of the warrant are valid and distinguishable, severance may be inappropriate where, for instance, the sufficiently particularized portion is only a relatively insignificant part of a sweeping search or where the warrant is generally valid, but as to some tangential item meets the requirement of probable cause. Okay. So basically, there needs to be a section that stands on its own, and it can't be a tiny section of the entire warrant. Here, the trial court applied the Galpin analysis when reviewing each warrant. One example of the trial court narrowing the warrant scope concerned a warrant for a cloud account affiliated with Demon's iPhone 10. See, this spacing just drives me crazy. What is this? I'm sorry. The supporting affidavit sought a warrant to track Demon's whereabouts around the time of the murders, but neither the affidavit nor the related warrant included a time range. The trial court limited the warrant to the time of the shooting and a few hours before and after. Makes sense. Again, they're just they just wanted the phone data for his physical location. The trial court explained the search warrant affidavit clearly indicated that Demons' physical location during and shortly after the homicides was of vital importance. Makes sense. Reminding me to breathe. See, I feel like people don't want to listen to me read, so I try to read it fast. The order noted that police officers had reason to believe the occupants of the vehicle were on the phone at the time of the shooting. The defendant had called his mother just after the shooting. That defendant's phone was in use and communicating with cell towers around the time of the shootings. The call data records revealed that defendant was using other forms of communication on his phone, although police could not pinpoint which specific forms were used. Yeah, true. I guess if you're watching this, you want to listen to court talks. That's kind of the whole concept, really. Let's see. Considering that time range, the trial court identified 5 categories of evidence, limited those critical hours while suppressing the others. This temporal narrowing comported with the warrant's stated purpose to locate his whereabouts to link him to the double homicide. We agree with the 11th Circuit's observation that the preferred method of limiting the scope of a search warrant for a cloud account will usually be time-based. When suppressing evidence, the trial court temporarily limited other warrants associated with digital storage accounts such as Snapchat, Facebook, Instagram, and Gmail. Having reviewed the record, we conclude the trial court did not abuse its discretion. Okay. Real humans reading things on YouTube. Yeah, I didn't mind like when there were a few like AI YouTube channels because some of them were actually like okay, and I feel like people just didn't want to read them. But now it's just like an overwhelming percentage of, particularly shorts, are just all AI reading. And like, who knows if it's even true? Okay, now that we've had a few minutes for people to get here, exactly 15 minutes. I want to go into some stuff. I want to talk about some stuff. I have some thoughts. I have some ideas. Some things to say. Oh, hey, Aaron. So, first thing I want to say is that none of this stuff was this isn't like privileged stuff. This isn't stuff that I had to like ask Antonio about. This was stuff that I discovered I think mostly before I'd even spoken to Antonio. This is all like publicly available information. It's hard to look. It's hard to like it's not readily apparent. You have to like look for it, but none of this stuff is like privileged or anything like that. This is all publicly available information that certain people should have checked before talking about it in court. But this first one, I don't think I've shared this one with anybody. Because it's not directly relevant, but I think it's interesting. It was vaguely referenced during the YSL case. Let me see here. So this relates to the 1428 Adele Avenue shooting in 2015, on April 28th, 2015. This was the one that allegedly involved Garlington and who was the other one? Quindarius Zachary. And you may remember, this is the case that was the Alford plea that one of the prosecutors read into the record and almost led to a mistrial. The factual acknowledgments from that case were, inappropriately read into the record because it was an Alford plea that almost resulted in a mistrial. So what wasn't discussed in the trial was that there are actually two guilty plea hearings. And this that we're looking at right here is actually the first one. This was not discussed at the trial, at the YSL trial. The one where the Alford plea and the factual acknowledgments and everything was read in, that would be this one? Yeah, this one here. So this is the one with the Alford plea. This is the one that was discussed during YSL. This is the one that was not. As you'll see, it didn't go all the way through. You'll notice that the prosecutor was Adrian Love. It was not Charlie Bailey. So Adrian Love was actually on this case, the Alford plea case. So she absolutely should have known that she knew the details of the case with the Alford plea. It wasn't ignorance that led to her reading. Hold on, let me make sure. Okay, good. I want to make sure I didn't have any notes on there. So this is the guilty plea hearing, the first one. And I want to show you an issue. Here we go. So this was going to be a blind plea, or non-negotiated plea, which means there's no plea agreement in place. And to that end, Adrian Love is going to read the sentencing range for each crime. So she's reading aggravated battery, 1 to 20 years, 1 to 20. She says the sentence range for criminal damage to property in the second degree is 1 to 10 years. That's actually incorrect. It is up to 5 years. Let me see. This is 1 to 10. This is 1 to 10 years. So this is wrong. This is also wrong. She's overstated the potential sentence by a total of 15 years. Ooh, that's way too bright. Okay. For possession of a firearm during commission of a felony is 5 years consecutive. That's correct. That's 1611-106. I think she reads through it twice, actually. This is also wrong. This is the same one I mentioned before. This is 1 to 10. Same charge, again, 1 to 10. She's going to give a total at the end, so I'm just going to skip forward to that. Do you understand that this is a non-negotiated plea or a blind plea? The state will make a recommendation, and the court, however, will sentence as it sees fit. So it was a blind plea. We're going to do a quick colloquy. There is some confusion here. Derek Wright, there's nothing wrong or incorrect about this. Derek Wright thought that the court was going to give Antonio the opportunity to withdraw his guilty plea if the sentence was excessive, which is permissible. You can do that. But the judge said that he wasn't going to do that in this case. You see here, he finds out that they're not going to be allowed to withdraw, so he says we're not going to proceed with the plea. And some discovery issues here. Okay, here we go. We're going to go count by count, and we're going to read through these sentences. So this one, hold on, I'm going to get my spreadsheet up so I'm not wrong. Okay, yeah, it's count 6. So count 6, this one is wrong. This should have been a maximum of 10. Count 7 was a maximum of 5. And then 11 was, she said max 20. That's actually 10. And then count 12 was also a maximum of 10 years. Court says that's 170 years, question mark. That's actually roughly the correct number. And Attorney Love says, no, Your Honor, 185, 200 for a total of 210 years, which is the total of the numbers that she read out. The total is it's the total of the years, but it's not the right number of years. The actual is either the judge said 170 question. I think it's actually 175 would be the maximum. So she overstated the prospective sentence by about 35 years. So the court says, can you give me the year of potential release for the defendant? This is 2017, 210 years from now. Love says 2228. The court says, so the defendant would be eligible for release in 2028. Love says the court were to sentence him consecutively on each of the charges. Yes, if he were sentenced to the maximum, he would be eligible for release in 2028, which, as you might know, is off by roughly 200. That's going to say zoo. I was going to do this. 200 years. So, the court's saying he'd be eligible for release in the year 2028, when in reality, he would be eligible for release in 2228. Now, see, 2028 is roughly 3 years from now. 2228, that's like when Star Trek's happening. So it's off by roughly now to Star Trek. I hope you guys appreciate my little explanation here. I don't know what else is happening in 2228. That's all I could think. You're not supposed to be good at math. Well, I have an accounting background, most lawyers are terrible at math. Okay, so I'm not done with this case yet either. Naturally. Let's see, 2018. Okay, so this is the case where the Alford plea was actually entered into. And you can see here, there's a different attorney at this hearing. Charlie Bailey is actually, I think he's a pretty good lawyer based on everything that I've never met him or seen any of his cases, but just from reading transcripts. And Brian Steele calls him the Honorable. So, I trust him. This cracks me up every time. Actually, I want to show you a video of this first. Let me pull that up. No, not a video of myself. Okay, here we go. Just need to switch to show you a little YouTube clip. Day 122. Here we go. This one, I think. Let me know on the sound here. That lady grinds my gear.
I can pause there. Okay. Was that factual basis?
That sounds slow.
Were those words read to the court by the prosecutor at the time you entered a guilty plea in 2017?
I don't remember. Was it read?
It was 2018, by the way, not 2017.
Prosecutor, because I took a blind plea, and I think the judge read off the evidence. I don't recall what it was though.
Okay. Do you recall?
By the way, just to be clear, this part annoys me so much. This is one of the most annoying segments of this testimony.
All hearing those words read by somebody in court as the reason or the factual basis for the charges that were being brought.
If I can explain, I pleaded guilty because I felt like it was in my best interest. You had two co-defendants. Some of what they said was true, and some they said wasn't true. But I did plead guilty because I.
To be clear, it's actually worse than this. It's not that some of what they said was true and some of what they said wasn't true. It's that they gave conflicting reports. So Garlington said one thing, and Garlington and Zachary, they gave different versions of events, and the court allowed different versions of events. So when he's saying some of what they said was true and some of what they said was not true, that's just objectively correct because they gave completely conflicting testimony. And if you read through here, actually, I think it's not in this one. I think it's in a different, I think it's in Garlington's transcript. But yeah, so Garlington and Zachary gave conflicting information of the guilty plea. So when he says they gave some of it was true, some of it was not true, that's just completely correct. That's undeniably correct.
Felt like it was in my best interest.
That is also correct. He was an Alford plea in his best interest. Completely correct.
Were you given an opportunity to say anything at the time that you entered that plea? Were you given an opportunity to make any statements?
No, not that I remember.
Do you recall the judge, after those statements were read, asking you, is there anything you'd like to say before sentencing?
So after the facts were read, Did the judge ask if there's anything you'd like to say before sentencing? Let's see. I'm going to come back to that. This case was just vacated, by the way. Let's see. His lawyer, did you die when you heard his lawyer say he didn't read his plea agreement before he had his client sign it? I wasn't. Yeah. I mean, I have a theory on what happened. I mean, it was a mistake. It was a bad mistake. But you know what? I'm actually going to get to that because I feel like I said Derek Wright, like the player for the Celtics. Derek Wright has gotten too much criticism. I think he was tricked, but he was pretty clearly misled. But this case was actually, this is Dominique Carter. This case was actually just was vacated. This guy right here is represented by Brian Steele. This guy, this guy is represented by Kyle Winchester. And I'm not sure who represents Carter. It might be, I think it's Brian Tevis. But yeah, this is Steele. And this is Winchester. And they're getting a new trial. Some of you may, some of you may remember, I actually watched the argument in this case. This was the case where the judge on the left was like ready to fall asleep because he'd already made up his mind because it was it was pretty clearly going to get vacated. But anyway, was Sledge asked if he had an opportunity to add stuff at the end? There's, they're not asking him if he had something to add at this point. That didn't happen. One other thing I want to add. There's no evidence that Mr. Sledge had a gun. He was just the driver. That is correct. So he wasn't the shooter. But yeah, that part about asking if there's anything you'd like to say after the reading. This is Darren, not Aaron. The subset was, by the way, Haiti Gang, not If Gang. Okay. But okay, so that part was untrue. So let's go back to the video. I kind of rambled on that part. Sorry about that. I'm going to try to keep it a little more succinct.
Do you recall that happening?
Yes, I recall him asking me that.
Do you recall telling the judge, no, sir?
I remember telling him, thank him for the plea that he.
That is correct. That is what he said.
Allowed. I remember that. I remember me telling him, thank him for the plea that he accepted on the non-negotiable plea, the blind plea or whatever it was.
Would you explain to the jury what your understanding of a blind plea is?
A blind plea that I
She's trying to make him look stupid here, by the way. That's clear, or dishonest. But we're going to...
You leave the evidence up to the judge, and the judge determine on the sentence.
At any time, did you tell the judge, I'm not admitting this, I'm just doing this because it's in my best interest?
Well, I didn't tell the judge that. I told my attorney that. When my attorney asked me...
Completely correct. That's exactly what happened.
When he came to me with the plea deal, and I told him, I said, well, I take the plea because it's best in my interest. You got two guys against one.
Hold on.
Completely true. Everything said true.
At the time that you...
No, I didn't tell it to the judge.
That wasn't the question.
Oh.
At the time that you pled guilty, did you know what sentence the judge was going to give to you?
No,
That's correct.
not that I know. I just knew it was
Did the judge, was it explained to you that you could receive up to the maximum sentence on each charge?
not if I understand. I think a deal was already worked out.
Okay, he's correct. He could have received the max, that's true, but something was clearly worked out. Because if you look at the recommendation, here we go here, it wouldn't have been binding on the court. But, wait, how do I spell recommendation? This is embarrassing. I feel like it should be 2 C's. Okay, here we go. Do you understand that this is a non-negotiated plea, otherwise called a blind plea? And what did Sledge testify to? He said it was a non-negotiated plea or a blind plea, whatever you call it. Do I have my own law firm? Not really a firm. I just kind of do my own thing. I'll let Greg do the rest. Meaning I, on behalf of the state, will make a this is Charlie Bailey. I, on behalf of the state, will make a recommendation about what your sentence should be. Totally fine. That's consistent with what he's testified to. Let me see. Actually, I should go down further. This is not the right part. Here we go. I'll read this part. So the court, make the officer pull up the state's presentation. Mr. Bailey, just in addition, Your Honor, the honorable member, the co-defendants, Garlington and Zachary, have pled. The state's recommendation for both of them was 30 years to serve based on the evidence that they were the shooters. Your Honor sentenced them to 10 years to serve 3 for both of them. State's recommendation for Mr. Sledge is 15 years to serve. And again, it was 30 to serve in the prior case. For the other two, I mean. So they're recommending half for Sledge as opposed to Garlington and Zachary, even though it's a non-negotiated plea. Public defender? No. The state's recommendation for Mr. Sledge, 15 years to serve, and that lesser amount is based on his evidence that he did not have a gun and that he was a driver. That concludes the state's presentation. I'm going to come back to this. I am going to come back to this one. Oh yeah, like and subscribe, guys. So you'll notice that even though there wasn't a plea agreement, you can tell from the context. Let me see if I can find an example that Wright and Bailey had spoken beforehand and had worked something out. 5 years. And you can see Wright and Bailey are like communicating with each other as to what the sentence would be. So you can tell from the contextual clues that they'd worked something out in advance, even though it wouldn't have been an actual plea agreement. So listen to what Sledge says. And remember that what Love is saying is she's trying to make him look like he's being dishonest or doesn't understand the difference between a blind plea and a negotiated plea. But he clearly
Did the judge, was it explained to you that you could receive up to the maximum sentence on each charge?
Not if I understand. I think a deal was already worked out, if I ain't mistaken. That would make me take.
And again, that's what we just looked at. The deal was worked out.
I think it was already worked out between my attorney and the state.
Do you understand the difference between a negotiated plea and a blind plea?
No.
Okay. Have you done anything besides a blind?
Wait, did I miss that? Do you understand?
Okay. Do you understand the difference between a negotiated plea and a blind plea?
No.
Okay. Have you done anything besides a blind plea in front of a judge before?
Yes. I think I have, yes.
And
That's correct.
when you pled guilty on December 28th, 2022, was that a blind plea or something else?
I think it was just.
I don't even know the answer
Yeah,
to
it
that
wasn't a
question.
blind plea, though, if I'm not mistaken.
Or something else?
I think it was just a plea. It wasn't a blind plea, though, if I'm
Also, again, correct. Completely correct.
not mistaken.
For a regular plea, what do you understand to be the terms? In other words, do you know your sentence before you plead guilty with a regular plea?
You never know your sentence before you plead guilty. So that doesn't make sense.
I don't know, because before the blind plea, I knew my plea.
Why did you then distinguish for the jury that it was a blind plea?
It
He was right.
but I already knew the sentence. My lawyer
He's completely correct. Everything he's saying is correct.
had already aware to me that they was offering the same thing. They was offering the co-defendants what they had pleaded guilty before me.
Okay.
So when I pleaded
That
guilty,
wasn't quite right. It was actually even less than they'd offer him.
my lawyer aware me that they was offering the same plea deal that they gave them. But in my plea deal, I told my attorney, like, I didn't want the probation. I just take the straight prison sentence.
Okay.
Smart man.
All right, outside the presence of the jury? Okay. Yes?
Yes.
Okay. I'm going to excuse y'all to the jury room.
So essentially everything that he said was correct, and the only thing he was wrong about was actually more favorable to the state than it was to him. So the only mistake he made was bad for him, not good for him. But he was correct about literally everything that he said, even though the gist of it was that he didn't know the difference between the different kinds of guilty pleas. So everything he said was completely correct. And people looked at this and thought that he was dumb, or that he didn't know what he was talking about, or that he was lying, when in reality the opposite was true. He knew exactly what he was talking about, and he was correct. He was being confused by the fact that he was being asked nonsensical questions, but everything he said was correct. Literally everything. Also, her hair is looking fantastic. I kind of want to listen to Brian real quick. So I think we're going to just go ahead and listen to that part.
To do what? Sure.
And I just want to reiterate. So Brian's about to go into the Alford plea issue, or the factual acknowledgments, or the factual basis to the Alford plea. And again, this isn't like Love was on this case. Remember, I just showed you a second ago. Let me show you here. What? Oh, right. You should be able to see that now. This is the. Hold on, let me switch. Sorry, I was going crazy there for a second. Oh, you couldn't see the video? Oh man, I'm sorry. Yeah, I'll switch it to you real quick. But Love was actually staffed on the case in which the Alford plea happened. So it's not as if she was, in the dark. This was her case. So she absolutely should have known, did know or should have known that it was an Alford plea. Okay, I'll go back to the video. You guys should be able to see this now.
Yes, sir.
Thank you, Your Honor. Your Honor, I have a motion for a mistrial. The evidence has just come out that two co-defendants who, to my knowledge, at least one of them is not testifying and has entered a guilty plea. That is a confrontation clause violation to Mr. Williams and the other people on trial. In addition, Your Honor gave an instruction with the last line, and I know it was objected to previously, but I want to stress this, that if it's a prior inconsistent statement, it can be used against Mr. Williams and the other people. That was premature, because I don't believe there's anything inconsistent as of now. And then the third reason I'm moving for a mistrial in the aggregate, Your Honor, is that the prosecutor uses and reads the statement of the then prosecutor, I believe it was the Honorable Mr. Bailey, who entered this plea.
That's right.
And gave a factual basis. But she did not make it clear that the Honorable Derek Wright said on page 12 of this transcript to the same court that Mr. Sledge is tendering the plea under Alford, which is ALFORD.
Yeah, I'm seeing the same thing. And honestly, I thought that we were going to be dealing with the guilty plea that he took in this case. And yeah, that's problematic that this 2015 case is an Alford plea. And so I don't think that any of what I said with regard to admissions is actually true, even against this. I mean, he's saying he pled under Alford, and I don't know why the disposition sheet doesn't say that, but it is.
This is actually something I've never gotten the answer to. Judge Whitaker says the disposition sheet doesn't say that it was an Alford plea. I hope someday to get an answer to this. But if you look here, it says Alford, like, and it's also marked as a negotiated plea. So, you know, Antonio being confused as to whether it was a blind plea or a negotiated plea is also funny, because the court was also confused because it marked it as a negotiated plea.
He pled under Alford, and I don't know why the disposition sheet doesn't say that, but it is.
See that? The disposition sheet doesn't say that, but it does say it. So I don't know what happened there. Maybe she might have been saying like it should have said something up here, as opposed to down here. But I was always curious as to why that, like, what document was being shared with the court. Okay.
Very clear that this is an Alford plea in this 2015 case. So
She's right.
Mr. Wright wants to share something.
Yeah,
Yes,
was
sir.
waiting for the appropriate time that I was going to point out that it was in fact an Alfred plea. So I thought her cross-examination was not appropriate.
Well, y'all, I mean, maybe that, yeah.
It was something other than Alfred. So
Maybe don't wait so long next time.
He has absolutely no obligation to say anything. It's not his job.
But I mean, I'm definitely going to, Ms. Love, do you want to be heard?
Yes, please.
All right, go ahead.
One, we'd ask that the court deny the motion for mistrial. Number two, we would ask, as it relates to the
Am I going fast enough?
assertion that no inconsistent statement was made in the factual acknowledgments.
Okay, no, see, that's the deal with an Alford plea, is you are not acknowledging that the facts are true like you would in a regular guilty plea. You're saying,
Okay, I'm sorry. This is just self-indulgent at this point. I'm just enjoying listening to this. Okay. So let's go back. Actually, I know what I want to show you. I'm going to show this version to you in the revocation hearing. Let me see. We're going to look at the 2004. Here we go. I also have the transcript because I know somebody. Here we go. If you streamed Lucky's script. Let me see here. This is... Okay, here we go. So some of you may recall that I have mentioned once or twice that Mr. Sludge's prior convictions are not actually his prior convictions, they're somebody else's. And I've mentioned it a lot in... I was going to say... yeah, the revocation hearing, prior convictions reported by Officer Jolly were incorrect. But it wasn't just in the YSL case. It actually dates back before the YSL case. So I'm going to show you this part first, and then I'm going to show you the same in a prior case.
The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, used.
Oh, I'm going to get into that too. I'm kind of doing this like off the cuff because there's just so much. But okay.
Prior probation violations.
Well, currently, he'd used his first offender twice, one for
We're going to touch on that.
DeKalb County, one for Fulton County.
Well, that's lucky.
The DeKalb.
Since you're only supposed to get to use it once. Okay.
Okay, this is one thing that drives me crazy. Judge Whitaker is obviously correct, but that should have been a red flag. That should have triggered additional review of the facts. Here, somebody used their first offender twice. That's curious. We should look into that.
Yes, so the DeKalb County case 04CR 24799, that was theft by receiving stolen property, felon and a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th, 20.
It was a misdemeanor. I don't know why she said felony. And I'm going to, the theft by receiving was objectively not theft by receiving, but we're not going to go into that right now.
2005, I'm sorry. He used his first offender. The second case, 04SC23.
That was correct, by the way. He did use his first offender in that case.
883.
And he successfully completed it.
That's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was.
I'm going to show you, this will only take 2 seconds because of how easy it is to verify this information. Let's see here, 2004. Which folder do I have it in? This one, I think. Oh, where do I have you? Oh, that's funny. Sorry, I'm going to my folders of other Antonio sledges to see if I can find 2004 DeKalb. Where's the Fulton one? Okay, I can just pull it up online. It's no big deal. I suspect some of you may know where this is going because I've talked about it before. I think it made it into one of our briefs. But the 2004 is, what was it? 04. Sorry about this. I thought I had this one. That's so funny. This is embarrassing. Here we go. Actually, I'll just switch so you can see what I'm looking at. Ooh. That should be a little better. This is the case number. Hold on, I'll go back a second.
That's Fulton 388.
Show you here. This is the case number here. I'll play you the audio so you can see it's the same case.
The second case, 04SC23883. That's Fulton County. He used his first offender. That was possession.
Whitaker did better than Granville? Yeah, for sure. I think, or Glanville. So 04SC23883. Thanks, Aaron. I'm going to pull that up, actually. I explained what this PO did to my mom. She was pissed. Yeah. You can clearly tell she's reading. That wasn't Antonio's, that wasn't his PO. Nobody knows who this person is. Final disposition, pull it up here. He pleads simple possession. You see, it is a first offender, but it's Anthony Bernard Sledge. And I did verify. I did a whole bunch of work to verify dates of birth and whatnot. Why didn't she have to be sworn in? She did. She wasn't sworn in, but she did have to be sworn in. I think Tiffany mentioned that in her part of the appellate brief. But this is it was a 3-year first offender. So this was the second of the 3 first offenders that Antonio Sledge supposedly had. So if he's used his first offender 3 times, had triggered an inquiry into the facts, this all would have been revealed. But everyone just kind of laughed at it and went along with it. But okay, so this is the 2004 cocaine case, right? And I've mentioned this before within the context of the YSL case. But if we go back to the case, the 2015 case that we were just looking at, you'll see that the same incorrect information was given in that case. Let me see this one. Yes, this one here. The defendant had a case in Fulton County. You can see this, right? Yeah. The defendant had a case in Fulton County for possession of cocaine. That sentence began in December of 2004 and ended December 9th of 2007. So this right here, remember, it was 3 years for Anthony Bernard Sledge. There we go. This is also, this is the same case. This is the same error. Who does check marks like that? So this is the, this has actually been following him for, what was this, 2018? So like 7 years at this point. Hey, YouTube streets. Yeah, YouTube streets and I might do something else sometime. But yeah, so defendant had a case in Fulton for possession of cocaine. That sentence began in December of 2004 and ended December 9th of 2007. That is incorrect again. And this was the 2015 case. So Antonio has been dealing with this mistake for 7 years minimum at this point. So this actually goes back very far. You have to go back to 2004. Thanks, YouTube. You have to go back to 2004 to fully understand all of the incorrect information that was given about Antonio, and it has followed him for several years, for many years, and goes back to that prior case entirely. Did Attorney Wright say anything this time? Not this time, but it didn't affect the deal, so it's less of a big deal. And he didn't represent him in that case.
Possession of cocaine, as well as a possession with the intent to distribute cocaine.
Wait. Let's go back to video so you can see. Nope, not you. Where are you? This one? Here we go.
That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, he used his first offender.
I suspect you probably see where the tap heading. Fair. That's valid. Okay, let's go to that case. That did happen. That was a legitimate conviction, probably the first one. Let's go to 2014 case. Ooh, I gotta save this as something else. Actually, open with photos. Okay. Should be able to see this in a second. There we go. So you'll see here that, this is, I can't edit this. But there are basically two things you can get. One is it says first offender / conditional discharge. First offender is your first offense. Conditional discharge, it doesn't say it, but it's a drug offender conditional discharge. So if you've caught with drugs or using drugs or whatever, and you complete all of the, rehab or whatever they send you to, if you stay out of trouble, you can get your the offense discharged. So that's what this is. This isn't a first offender at all. He only used his first offender one time. Drug court, yeah, exactly. Not negotiated plea, but yeah, it was not a first offender. He only used his first offender one time, and the only time he used his first offender was the first time he offended. even though he didn't offend because it wasn't a crime. But, you know, it is what it is. So the thing about using first offender 3 times is completely incorrect. So I've gotten through 15 seconds and almost everything's been incorrect. But let's keep going.
The next case is 15 SC 138994. That is.
So this is the case. This is the Alfred plea case that we just looked at a second ago. Remember, it related to the maybe drive-by shooting. It's not even clear if it was a drive-by shooting, but
The Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery.
okay, I've harped on this one once or twice, but just to one more time, just to show that never happened. Although, if you've watched this for a while, you probably know that you probably heard me complain about this before. But there's no sex battery or aggravated sex battery. Like, this just had nothing to do with sex crimes. It wasn't that even related to that. It just wasn't. That's not what it was. It was Club Crucial and the parking lot outside of Club Crucial and Adele Avenue. But it just had nothing to do with with any kind of sex crime. So that's completely incorrect.
Aggravated battery.
Oh wait, I gotta switch back. I'm not very good at this yet.
Aggravated assault, criminal damage first degree, criminal damage second degree, and
True.
possession with a firearm by a convicted felon. That was January.
Did you hear that last one? I haven't mentioned this one as much, but that's also incorrect. So possession of firearm by a convicted felon. Look through here. That would be 1611 131, which is a sequence of numbers you've probably heard me say a million times before. It was 1611 106, if anything. So that actually never happened. That one is also incorrect. And be clear, the judge explicitly found that Antonio didn't possess a firearm, but somebody that he was with did possess a firearm, and that is why he was charged with it. Aaron, if you completed first offender, yeah, Whitaker's actually about to make the same point.
10th, 2018.
All right, so given the fact that he had at that point a possession of a firearm by a convicted felon, does that indicate that at least one of those first offenders was not successfully completed?
Beat her to the punch, Aaron.
One
Or are we missing?
Okay, and again, remember how I just mentioned that there was no 1611 131? This is another red flag moment where if people had looked into this, they should have discovered the mistakes.
Felony.
One moment.
Stare down. Just stare down right at the papers.
That would be correct, Your Honor. In addition,
And again, Attorney Love was staffed on this case. She was the one that she heard the first guilty plea in this case. She had read these offenses into the record in 2018. She had read, everybody knows the 15 SC case. She spent days asking Antonio about this case. There's absolutely no chance that she didn't know that these charges were incorrect. It's ludicrous. She absolutely knew what mistake was being made.
of course, the current case that he is currently on probation on. As far as previous revocations,
So, hang on. So the 15 SC and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
there's nothing in between the two of them, no.
Okay.
Aaron's favorite person is about to speak. General confusion.
Are you looking about prior revocations or prior violations?
Yes, at this present time, I don't see any prior revocations. There was one documentation. It's a little bit,
I'm not going to
I
get into this.
guess,
It's too technical.
I'm having a hard time understanding what they meant by it. One moment.
Judge, while she's pulling that up, there is a 13 SC 123423 out of Fulton County. It's a VGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th, 2014, which would be the predicate or basis for the possession of a firearm by convicted felon of the 50.
Okay. Here we go. Everything you just said, that's not true. Virtually everything you just said was false. So remember, the question is, what was the predicate conviction to the 1611-131 in this case right here? There was no 1611-131 in this case right here. So I mentioned this in my brief. I think I've talked about this before. But if you have a 1611-131, you have to have a predicate conviction. There was no 131, so there was no predicate conviction. So what he's saying is false, and not only is it false, it's covering up. It's a lie about the predicate to cover up the fact that the underlying offense doesn't exist. So now we're like stacking misrepresentations. Second of all, listen to I don't think this was intentional, what I'm about to say. But here we go.
There is a 13 SC 123423 out of Fulton County. It's a VGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th, 2014.
That was already read into the record. That was already listed by Officer Jolly. I don't need to go back. I can show you the transcript, actually. Let me see. This one. That is this case right here. This is the 13 SC case. Was it 123423? I can't remember. I was right. It's 123423. So this one was already read out into the record. And so in addition to misrepresenting the underlying offense to the 131 that didn't exist, like both things didn't exist, now it's like he's also duplicating a prior conviction. So he's making it sound as if he has an extra conviction that he does not have. So now we're like three layers of misrepresentations deep. See here, this one right here. 2016. I didn't think that's what he said. I think he said 2015 or something. I said 2016. This transcript might be wrong.
Which would defendant received 5 years probation on January 7th, 2014.
Yeah, this transcript's just wrong. I should have said 2014. That's funny. And by funny, I mean not funny, but looks like the transcript was wrong. Why does YouTube suck today? I don't know. Aren't I nice? I feel like I know what is. So yeah, there's this duplicated prior reading of that case. It also misrepresented underlying conviction, and then it also propped up the non-existent 131 read by Officer Jolly. And again, I don't think Officer Jolly had any involvement in this. I think she was just reading the report that she had. And I think she acknowledges that in her testimony. So I don't have anything against her. So yeah, this one statement was actually three misrepresentations in one. It's actually it looks like it's 6 lines of text. So 3 misrepresentations in 6 lines, roughly 50% misrepresentation to text line ratio. That's usually pretty bad. Usually you want to be like 0, but 50%, that's not great. And actually, you know what? Let's do a little bonus thing. I wasn't going to talk about the appeal, but let's get into this. Let's get into this real quick. I can throw in a little extra here. Oh wait, no, I wrote this. Not this part. The part that they wrote. Here we go. There we go. Okay. The probation officer listed theft by receiving stolen property. That's correct. A possession of cocaine case out of Fulton County. She did say that, but it is incorrect. That was Anthony Bernard Sledge, who, by the way, I believe actually got clean after a 2008 case. So give credit to Anthony Bernard Sledge, living on the straight and narrow, proving that first offender does work. Let me see here. Possession with intent to distribute from Fulton. That was the conditional discharge. So that's fine. But then they say, and this is their brief, so this is like a couple weeks ago. And the attempted aggravated sexual battery. She did say that. So that's, she did say that. But it says that was the underlying charge to count 30. This is just completely made up out of nowhere. I have no idea where this came from. There you go. You can see that better. The attempted aggravated sexual battery, that was the underlying charge to count 30. I'm very small but full of rage. For some reason, I have this highlighted already. But if you look here, there's no sexual battery because it didn't exist. It was not the underlying conviction. That's just completely wrong. And if you just took a second to read the indictment, you'll know that that's incorrect. That's just it makes no sense. I mean, it's just completely frivolous. Attempted aggravated sexual battery is the underlying charge to count 30. It's just not there. It takes 2 seconds to verify this. This isn't even like being a lawyer. This is just like reading. So that was just, I mean, it's completely incorrect. The sun's really in my eyes right now, so I'm going to close the window. Oh my goodness. Okay. Yeah, we did YP. I mentioned it. Where did I write that? I wrote most of this reply brief. Where did I put you? Was that before? No, I put it after this. I mentioned it here. It is part of the reply brief. I originally had it in stronger language, but I had to I had to tone it down a little bit. Well, let's see, what else do I have? All 3 times theft by receiving. I could look at that. What else? What do I want to show you guys? Let's watch the opening statement. Hey, Ellie.
Probation revocation.
Revocation for the defendant as to his violation of a special condition within the Senate.
You guys may recall the special condition thing. I've talked about this. We're going to listen to this. See if you hear the phrase special conditions, if he ever says he violated a special condition of probation. Oh, show the video. Good call.
From Judge.
There we go.
Within the Senate's for the defendant.
There we go.
As to his violation of a special condition within the sentence that he received from.
A special condition within the sentence he received. Actually, for some of you might not have seen this before. I'll show you real quick. And I'm actually going to show it to you. I'm not just going to say that I'm going to show it to you. No, not you. This is the current sentence. I need the original one. Where are you? There you are. Sorry, you guys are going to need to see like the true depths of my insanity. So this is Sledge's sentence. You'll see here it says special conditions of probation. And then what follows is something else entirely that says negotiated sentence. Then it says count 30 until the completion of the initial trial of this case. I know Kat's talked about this a bunch of times. This doesn't mean anything. This is gibberish, but it's definitely not a special condition of probation. It says special conditions, and then it says outlined special conditions of sentence of this plea agreement in caps. And then what follows is something called special conditions of sentence. So the issue is that there aren't any special conditions of probation here. There's special conditions of sentence. And then here again, it says special conditions of sentence. Kind of a problem. So the issue is that the sentence just doesn't include any special conditions of probation, like explicitly. Very clearly does not. But let's go back, and this is why I asked you guys to listen to see if he ever says special conditions of probation. He does one time in a very clever way. So let's go back to that, if I can find you. There you are.
Judge Glanville on December 8th of 2023 as a
It was December 28th, 2022. So it's 351 days off, but whatever.
Relates to his reviewing, acknowledging that the factual acknowledgments that were a part.
Wait, that wasn't right. 345 days.
Of the plea agreement in which he entered into.
Okay, again, the factual acknowledgments that were a part of the plea agreement. You can get violated, December 88th, you can get violated, or you can violate your probation by violating the terms of your sentence, not the terms of your plea agreement. Once you have this sentence imposed, the plea agreement just goes away. That's a simplification. But everything needs to be in the plea agreement. In the sentence, I'm sorry. So again, going back to the sentence, where are these special conditions? Select annotation. So where are these special conditions? Let's see here. In accordance with testifying truthfully about all matters relating to this case, you acknowledge that each and all the statements contained within the defendant's factual acknowledgement section of this agreement are true. What does that mean? What is this agreement? Because this document isn't an agreement at all. This document is a sentence. And you'll notice here, it says, up here, it says this plea agreement in caps. which I suppose means like something. I don't know what. And then up here it says this negotiated agreement. Then it says this agreement, and then it says the agreement. So where are these conditions? Or I'm sorry, where are these factual acknowledgments? It says within the defendant's factual acknowledgement section of this agreement. Where are they? Are there factual acknowledgments in the plea agreement? Yes. Well, no, actually. But maybe there are, but there aren't any in here, which is where they need to be. There were no factual acknowledgments, but okay, let's go back to the video.
On December 8th.
You hear that? Part of the plea agreement he entered into, and he's going to say the date wrong, but the plea agreement. And some of, I think I've covered this before, but what he's referring to is, let me see, do I have it open? Where are you? Why are you not where I want you to be? Oh, here you are. He's talking about this document here. Oh, hey, Kierna. I got your message, by the way. I need to, I'm going to check that out, that case you sent me. Yeah, he's referring to this document, which is not actually the plea agreement, aside from the fact that it has the wrong date on it. You see here, sentencing withheld. So this is actually not the plea agreement that was in effect. So that's also wrong. But let's keep going. I'm interrupting too much.
Of 2023.
22.
I have a certified copy of the conviction, for your honor, with a certified copy of the indictment, as well as a copy of the transcript of the plea that was taken on December 8th of 2023.
22.
An exhibit within that plea transcript is the plea agreement, which includes the
plea agreement
sections, I believe it's sections 4 and sections 5 of the plea agreement as it relates to the factual acknowledgments.
Okay, again, he is referring to sections 4 and 5. These parts here, defendant's factual acknowledgments and sentencing acknowledgments, which are down here. And I want to reiterate, the state, in their opposition to our appeal, explicitly admitted that this is not the plea agreement. This is not the right document. So, oral, I guess. Oh, there it was. This works. Between the written plea agreement, which is what he's referring to, and the subsequent oral agreement that was accepted by the trial court, he's referring to this one, which is not the agreement that was accepted by the trial court. The parties renegotiated a new plea agreement, which changed count 30 to a plea to 50. That doesn't make sense. It changed count 30 so that he would be sentenced to 15 years of probation. So, if you look at the plea agreement that Abade was referring to just a second ago, what are the terms of count 30? Sentencing to be withheld until the initial trial of this case. So that alone proves that this is not the right plea agreement, and everything that he has said about the plea agreement has been incorrect. And it doesn't really matter if it's intentional or not, because it's inexcusable, especially now that the state has acknowledged that what I'm saying right now is true, and what the Abate was saying at the time was not true. That's not even in dispute at this point. Yeah, it's everybody agrees that what was said during this hearing was false. It's not even me. It's not me arguing and screaming like a psycho at this point, although it is also that. It's just there's no dispute. Everything that he just said was false.
That the defendant swore under oath during the plea that he had reviewed, then initialed each one of the factual acknowledgments.
Okay, I know Kat went over this. If you guys watched her stream yesterday, he's reviewed and initialed. What did he initial? Did he initial the oral agreement? Because that's usually not in writing, because it's an oral agreement. So this is completely wrong.
And then
incorrect.
signed that he, again,
He also did not sign the oral agreement because it's an oral agreement.
and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called
Special conditions of his plea. Again, did not say special conditions of probation because he knows there aren't any.
to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate
The plea agreement, also incorrect.
statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day 124, 125, 126, and I think 127, Your Honor, but all of the defendant's testimony can be found on State's Exhibit 3, as everyone is
122
aware,
to
Your Honor,
125.
witnessed it and can take judicial notice of everything that occurred during the testimony in which Mr. Sledge did testify. And I believe the court during, I think it was day 125, helped direct the defendant to sections 4 and 5 of the plea agreement during the
plea agreement
testimony for him to focus on and read, and to go one by one and acknowledge or disavow is the only word I could really think as to being no longer true, and testifying under oath that he was.
Disavow is no longer being true. He disavowed a void plea agreement. So he was objectively correct, and everybody else was objectively incorrect. It's like saying I disavow the existence of the Soviet Union. Like, yeah. I think that's the second time I've used the Soviet Union as an example on the show. It doesn't exist. I disavow the existence of Czechoslovakia. I disavow the season of the Milwaukee Brewers. Like, it doesn't exist anymore. He's disavowing something that correctly, like, it's not there. It wasn't his plea agreement. It obviously wasn't his plea agreement. He knew it wasn't his plea agreement.
Violating the special conditions of his probation, Your Honor.
Yeah, he's right, and everybody else is wrong. Like,
At this
objectively.
time, I would tender State's Exhibits 1, 2, and 3 for the court.
All right, I'm not quite sure I understand what 3 is.
3 is a
State has
USB
enough
drive
evidence that a
with all
jury
of the
could be
testimony of the
convinced beyond
defendant.
a reasonable doubt
If Your Honor
that these
wants to
facts are
preview
true.
it or wants to be part of the record.
But you're not acknowledging.
Is that
on your
from
end-
the official transcript?
Well, it's the YouTube link, the live stream of all of the.
Okay, I'll just take judicial notice of it. I mean, if you want to make an exhibit, that's fine, but I'm not going to be relying on that.
So-
Since
Okay. I want to show you. Ooh, that's not going to work. And again, there's some stuff that there's more stuff that I'm not going to get into just because. It's for strategy reasons. Okay, let me see here. 314.
as you know, it's only the
That he
This is our next topic, although it kind of relates to the one we were just on.
first started saying why I said I don't remember.
Would showing you a document with your writing on it and a year on it that you signed on December 28, 2022, refresh your memory?
Yeah, it's dated December 27th for some reason. Also, I've whined about this before, but I'm just going to be self-indulgent here real quick. I'm going to do it again. You guys remember how this whole thing was about, like, which version of the plea agreement was the final one? Like, it's dated December 27th, 2022. And Antonio thought that the terms of the agreement were the ones that were entered into on December 27th, 2022. But the final version was actually entered into on December 28th, 2022. So, you know, for Antonio to think that he was entering into an agreement with terms from December 27th might be because the fucking state gave him a document that was dated December 27th, 2022. So now they're turning around and saying, obviously the agreement was from December 27th, 2022. You're an idiot. How could you possibly think that the agreement contained terms from December 27th, 2022? When you look at this document and it says fucking December 27th, 2022, 8 million times, or one time, I guess. I'm kind of exaggerating now. Like, what are you doing? I would get fired for that. Well, not now, because I don't have a boss, but I would have been fired for this. Like, are you kidding me? Oh my goodness. Embarrassing.
Yes.
Your Honor, I'm going to approach the witness with what I will mark as State's Exhibit number
I can't hear that.
444 Yankee. And
That, what she's referring to is this agreement here. So what she's about to hand Antonio is not his plea agreement, but it is going to be represented as his plea agreement. And it was represented as a plea agreement. So what she's about to hand him is clearly not the operative document. This isn't what she should be handing him because, again, as the state has acknowledged, he had a, where are you? They renegotiated a new plea agreement. It was an oral agreement that was accepted by the court. So what she's about to hand him, yeah, exactly. No matter what she hands him, it can't be the right thing. That's totally right. So what she's about to hand him is not his plea agreement, and it's going to be immediately apparent.
I will show it to counsel for either the defendants who wish to see.
Right.
How can they hand him the new plea agreement? It's in their heads. Yeah, it's an oral plea agreement. There's nothing to hand him. And also, just think about this for a second. He knows, like in 2018, when they were reading his prior convictions and they just started making stuff up. So he's been dealing with being lied to by the prosecutors for, I haven't said the earliest stuff, but for over a decade at this point. They continuously mix him up with somebody else entirely. He has no reason to believe that he's going to be told the truth because he hasn't been told the truth and he's going to continue to not be told the truth on the stand. And he's going to be right and everybody else is going to be wrong. And he's going to be, he's going to have to listen to misrepresentations by the state and be treated like he's a liar when he's the one telling the truth. I know, like, you know, everything's gaslighting now, but this is like literal gaslighting. You're going to talk to him like he's dumb. Yeah, exactly.
See what I wrote.
Any second now.
Just 1 second, Your Honor. I wrote on the one that I have, so I want to make sure I give him the clean copy.
It's just funny knowing that it's not on any paper. Like, it's not any of those. Again, Adkins is cool. I believe Doug and Max also want a physical copy. That's why they're standing. Curious. I don't even know what they're talking about, but it's interesting. It's Brian Matthews with his fantastic beard. Does she clearly know this? I don't know. She should. I don't know if she did, though. Yeah, I know, Aaron. That's probably the
For
thing.
the record, I am showing the witness.
That's exactly what he said. He said, I'm not as smart as you, Miss Love. My brain doesn't go as fast as yours. It's not like self-deprecation. He's like trying to figure it out. Like, he clearly knows that like there's something fucky, right? Like something's up, but he can't figure out what it is. But again, if you just look at the first page of his plea agreement, you'll know. Like, if you know what's going on, you can tell from the first page of the plea agreement that it's not the right document. Like, he knows that he has a sentence on count 30 because, like, you know, it's 15 years of his life. So as soon as he looks at it, he knows it's not the right thing. He's trying to figure it out.
The third page of the document. So page 3 of 7. And the second blank under section 4.
I'll show you that real quick. It doesn't really matter, but she is talking about this part right here. Again, this is from an outdated document. This isn't the right agreement. Everything. So this is the part that supposedly did get him in trouble. Everything is based on this written plea agreement that we're looking at right now. This was also, they're calling it a call it for a 44 Yankee. That's what this is. It's the same thing, 1AS or 445 OI. But literally, like, everything is based on this misapprehension or misrepresentation that this agreement, it matters. This incorrectly dated agreement matters. That's what everything's based on. That's everything. That's the old agreement should have been voided and trashed. Yeah. And again, that's kind of the thing is like they didn't trick him, but they negotiated new terms and then tried to hold him to the old terms. And that is not the way it works in theory. But okay.
So I'm going to show you.
Actually, there's one more thing that I should show you, just so you can see. I think I mentioned this, but the people, it was Love that was present at the plea hearing, so she should have personal knowledge of the fact that that's not the right agreement. either knew or should have known. And also Simone Hilton was also there. She wasn't directly involved. She didn't do the questioning. But they were both there. They both should have known that that's not the right version of the plea agreement. And they're both here during the testimony. Oh, wait, I'm not showing you. Hold on. I keep switching back and forth. Right here. You can see it's Love and Hilton that were there at the plea hearing. Although they only had Love on the cover sheet. It was both of them. They were both there. That part always drove me crazy. Someone should stitch all the... It's not a bad idea.
What has been marked State's Exhibit 444 Yankee, and I'm going to turn to page 3. Do not read any of this out loud.
Right.
I'm just going to point to the second blank under section 4 and ask you to read it.
I don't know. We don't need to go through this part. He's just, as you may remember, he's just going to go through and talk through the terms of the agreement. And yeah, he's going to disavow the terms that have been disavowed by everybody because he's correct and everybody else is wrong. Let me see. What else do we want to go through? Going to force him to lie on the stand? Yeah, exactly. Again, these let me see. Do I want to show you? I could go into Wright's testimony, but I'll just type this out. It'll be, it's kind of, there's probably a better way to do this, but I think it'll work. So the timeline, the first communication between Love and Wright was, I think, November. It was sometime in November, but I think it was like the 21st or the 27th or something like that. I'll say 27th. There's almost certainly a better way to format this. Well, this will have to work. The first offer was made on December 27th. I feel like it was probably the 21st. I think I'm just mixing those up. Oh my God, the 21st. December 27th. I think it was like 5:03 p.m. Hold on, I'll do this here. Oh, thanks, Amber. I think that's my first one. I just got monetized, so this stuff's new to me. But thank you so much. Am I able to subpoena her email and phone records? I don't think so. Maybe some of them. I don't need to, though. I have everything. Like, that's the funny thing about this case is, like, everything's public. Was December 28th afternoon, I guess. Then the plea hearing was also the afternoon. So this is part of the issue was I'll be petty and throw this in here. Can you guys see this very well? Yeah, it should be fine. So if you're trying to get, an accurate set of facts, like all of the negotiations between Love and Wright during the trial were between here and here. I think this was at like 3:30 maybe. So all of the negotiations that happened with respect to the factual acknowledgments were in less than 24 hours. And again, Mounk Tounk's in jail. So Mounk Tounk is in Rice Street for this part. So it's not like he has the time to like talk to his family because again, he's in jail. So we're really talking like an incredibly small amount of time for him to like go through the factual acknowledgments. If you're trying to get like actual, accurate factual acknowledgments, you need to be starting, you don't need to start like a month in advance, but at least like a week or something. But they waited until the extreme last minute. His attorney had just had heart surgery. Yeah, he did. He's just been cleared to return in like October, I think. But I want to show you guys, I mentioned this on Cat's show yesterday. I think I might have mentioned this before, but let me see if I can have it here. It relates to the way the plea agreements were held. Yeah, let me close these tabs because you guys are going to make fun of me otherwise. There is something unique about Antonia's plea hearing that is interesting. Ooh, actually, I'm going to keep this. Here we go. Okay. Let's watch the plea hearing first. Man, it's hard to find this video. Where are you? I keep just getting the I'm looking on YouTube for the guilty plea hearing, but here we go. I kept getting the oh man, that's not it either. I keep getting the revocation hearing. I'm looking for the plea hearing on YouTube, but it's not coming up. That's okay. I can just use the transcript, I guess. That's okay. All right. So there is something unique about Antonia's guilty plea hearing that wasn't true for anybody else that pled guilty in December of 2022, which is when 8 people entered guilty plea. Here we go. Sorry, I have way too many things open right now. Sorry, I'm sure this is great viewing. Okay, here we go. You'll notice that when they're reading through the factual acknowledgments, when Love reads through them, she just reads through all of them just consecutively, right? I mean, you don't need to know why that's important yet because we're going to compare them, but just notice that there's no line by line waiving the fifth. Yeah, he did. There's no like line by line confirmation of the factual acknowledgments. She's just reading through all 16 of them in a row with no confirmation by Antonio that they're true. And then if you look at the transcript of the revocation hearing, the court says, and then when Ms. Love read it out orally in the court, and Mr. Sledge, one by one, said, yes, I acknowledge that. Somehow that didn't occur to you at that point in time either. And she's criticizing Derek Wright for not noticing when there's this one by one reading, for not recognizing that there was something added in. When Adrian Love went one by one through their factual acknowledgments. Again, that never happened. There was no one by one, read and confirmation with Antonio Sledge. Good thing Whitaker took judicial notice of this. Yeah, I mean, this wouldn't even be covered by judicial notice because she wasn't even there. So she couldn't have taken judicial notice of it. And there was nothing in evidence to support that this was true. So it's completely inappropriate. It's completely improper. But it just didn't happen. It wasn't before her, so she couldn't take judicial notice of it. But what's really interesting, I mean, this was interesting, but so this didn't happen. It was just a straight read through of all of the factual acknowledgments. Is this what I was looking for? I'm sure it is. Let me see here. How do I do this?
So basically,
hey, that was it. It's been viewed 750,000 times. Fantastic. Oh, man, I can't wait to sue them. Okay. I guess I can show you this real quick.
And is that initial AS your initial?
Yes, ma'am.
The factual acknowledgments are as follows. Number one, Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers that include, but are not limited to, colors, hand signals, and terminology, who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL. Number 2, defendant has been a member and or associate of YSL since 2012. Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demekion Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend. Number 4.
Wait, she didn't read it. That's not what it said. That's not what it said. This doesn't matter at all, but I'm going to pretend to be outraged by this. Oh, where are you? God, I have so many files. Where did you go? Where are you? Why are you not in the order I want you to be in? Here we go. I'm going to pretend to be outraged by this. This is just unacceptable. See, she said ex-girlfriend, but what it actually said, as some of you will recall, was ex-paramour. But this is actually probably my favorite detail in the entire plea agreement. It says ex-paramour and then girlfriend. But what ex-paramour means is actually ex-girlfriend. So what you really should have done here was done ex-girlfriend. So completely unacceptable.
Named Kel, used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend.
Oh, wait, you guys can't see that. Not that it matters, because she's literally just reading.
Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC 138994, defendant and fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section.
Okay. Yeah, the Paramore thing's just funny. Like, if you have to explain, like, this is just insane. This is really, like, in terms of, like, things that don't matter but are the most insane, this might be the most insane thing that they did in this entire case. Like, if you need to define it, like, just take this word and put it here, and then just get rid of this word. Like, what are you doing? Why would you do this? I don't understand it. Like, you feel the need to define the term right after, but then you do it wrong. Like, just say ex-girlfriend. And then when you read it out in court, you say ex-girlfriend anyway. Speaking of Shell Kell, he violated probation and is on Rice Street again. Okay. Like, what is this? Who even says Paramore anymore? Is Sledge on Rice Street? No, he's in prison right now. He actually got out of solitary recently, which is good. The other funny thing is there are like 15 ASs in this case. There's Antonio Sumlin, Trevor Smith. Oh man, what's understood shouldn't have to be explained. Yeah, I feel like they're just trying to be fancy by saying Paramore, but like then they just ruin it by. There's a brief written on behalf of the Georgia Gang Investigators Association that does that. I have to pull it up later. That was in Jimmy Winfrey's case, and it has one of the dumbest parentheticals I've ever seen. That's like, I say that a lot. There are a lot of dumb ones, but I wonder if I have it open actually. I do have it. Oh, this is exciting. I've never shared this, but this is my favorite case of all time, the Jimmy Winfrey case. Remember when everybody was on Twitter like arguing about whether Pee Wee Roscoe had entered a guilty plea? Didn't someone have a probation violation as well? He actually did. This is, you know what? That's my other favorite thing in the world. I'm going to show you guys that. Let's take a look at the state's petition to revoke Antonio Sumlin's probation. We're going to come to the footnote in this case. We're not going to look at that footnote. So this is the petition to revoke Antonio Sumlin's probation. But wait, it gets better. Oh my goodness. Okay. See, I actually read this stuff because I like it, because it's hilarious. Let me see, where are you? Condition D, you shall not have or possess no guns during the term of this sentence. Where was the other one? It's all in bold and underlined and in caps inexplicably. Where are you? Oh, here it is. It was right underneath it. You shall not commit no criminal acts. So this is in an actual petition to revoke, and they're actually doing it. They're actually saying the double negative. But then they go even further. Let me see if you guys can see this a little better. They actually try to revoke him on you shall not commit no criminal acts. I don't know. That was really hard to read, Kat. And why is this just in a different font? That's just weird. But yeah, so Antonio Sumlin, they tried to revoke him for "you shall not commit no criminal acts." Oh man. I don't even remember how I got on this tangent, but yes, they did file a petition to revoke before he testified. But then they did all of this nonsense, which is kind of funny. But okay, let's go back to my main point. Remember I was talking about the one by one reading? Not you. Here we are. We got Murphy. I'm not going to go through all of them. Let's go through a few. Kitchens. Get Wani Lee. Just a few examples. This is Wani Lee, aka Slime Life Shoddy, aka Freakway. We'll look through. Here we go. All right. This is Hilton. I'm going to go through these acknowledgments with you today just to confirm that these are the acknowledgments you made. All right. Yes. Number one, that YSL, otherwise known as Young Slime Life, is a gang. Is that one of your acknowledgments? Yes, ma'am. Two. Sorry, I was going to nitpick the grammar. I decided not to. Yes, ma'am. Number three. Yes, ma'am. Number four. Yes, ma'am. Same one. Yes, ma'am. So there's a one by one. She's going through one by one and confirming everything, right? This is Sergio Kitchens. God, I hope the internet doesn't get mad at me for reading this. This is Gunna, aka Gunna. This is actually, I think, where, I'll just go into this, whatever. There was confusion about whether this was whether Gunna's plea included factual acknowledgments, and some people were like confused on the difference between an Alfred plea and a factual acknowledgement. And his was kind of confusing in that it was both an Alfred plea, so he wasn't admitting the factual basis to the guilty plea, but there did include factual acknowledgments. So it was kind of both. All he admitted was the factual acknowledgments, not the factual basis. Where are you? Talking about the Rule 22. Gonna keep going. Hey, Gunna graduated from college? I don't know that. Where are you? Where are the facts? Okay, here we go. Additionally, as part of this agreement, you make the following acknowledgments: that all of the following statements are truthful. Please state after each statement whether or not you agree or acknowledge that the statements are truthful. Okay, yes, ma'am. I became affiliated with the YSL around 2016. Is that true? Yes. YSL is a music label and a gang. Says yes. You were present when law enforcement officers stopped the vehicle. Said yes. There's also a third person in the vehicle, which isn't mentioned here, but so he's going through and saying yes to each one. This also isn't even a fact. That's just an opinion. But you see, there's like a one by one, going through of the factual acknowledgments. Look at one more, I guess. This, which one is this? This is Tix, Trontavious Stevens. Let me see here. Again, a line by line. Is that one of your acknowledgments? Yes. Do you acknowledge that you were one of the founding members of YSL? Yes. And he keeps going through saying yes to everything, to each one, confirming line by line. And that's how you make sure that, they are, the agreed upon factual acknowledgments. And you go back to Sledges and you'll see that that didn't happen for him. And I didn't go through all of them. It makes it it makes it the most compound question to ever compound. He was the only one there were 8 people who entered guilty pleas in December of 2028. My list here, it was DK, Walter Murphy, Gunna, Sergio Kitchens, Arnold? Oh, Martinez Arnold, Duke. I was like, who is Arnold? Winnie Lee, Simon Shadi, Quintavious Greer, Antonio Sumlin, Trontavious Stevens. So those 8 people entered guilty pleas, and every one of them, except for Antonio, both Antonios. Antonio Sumlin didn't have any public factual acknowledgments, so he doesn't count. But of the other 7, Antonio Sledge was the only one who didn't do the line-by-line reading that we just looked at. And again, if you look at the timing here, hold on, where's my thing? If you look at the timing, he had unbelievably little time to finalize the terms of the plea agreement. So he was somebody that you would really, really want to do that kind of line-by-line reading to make sure that, you know, the agreements are reached. Hidden characters on, of course. This button right here, if anyone's wondering, you can see your punctuation. It really helps when Word is messing with your stuff. But because he was, all of his stuff was negotiated at the last minute, you would really need to, you would really want to do that kind of line-by-line reading if you were interested in getting accurate factual acknowledgments. Okay, what else do I have here? Where was I? Oh, I didn't have my thing on. Yeah, I had here. The timeline. So he had extremely little time. All between the, yeah. Where is my appellate record? I want to show you guys one thing that irritates the shit out of me. I think it was Index 1, maybe? No. I already have so many more tabs open again. This is embarrassing. Motion for bond. Where are you? There you are. 70. Oh, a bit too far. All right. This is a motion for bond that Derek Wright filed. It's just a standard motion. Nothing wrong with it. And then you'll see this is the decision denying Antonio bond. You see here, October 14th. Everything happens in October, apparently. October 14th, 2022. No bond as to either count 1 or 30. Correctly stated here, you'll see. Denied for the following reason. Defendant poses a significant risk of fleeing from the jurisdiction of the court. Actually, why else was it denied? Poses a significant threat or danger to a person, the community, or property. Poses a significant risk of committing a felony pending trial. Poses a significant risk of intimidating witnesses or otherwise obstructing the administration of justice. So notice this is October 14th, 2022, right? Then jumping back to our timeline, this is 2022, you'll see that roughly 1 month later, they begin negotiations for a plea agreement that would release Antonio before the trial happens. So, if they really believed that Antonio was a risk to intimidate witnesses, why would you let him out on probation a month later? Aaron says flight risk was always insane because in what world can he afford to flee the jurisdiction but not to continue retaining his private attorney? Totally. Actually, let me show you an interesting thing on that front. I had it open. I just closed it because I closed my tabs at the worst possible time, apparently. No, not you. This one, I believe. No. This was the 2018 case. This one, I think. No, not this one. Here we go. He actually, in 2018, this was after he had been convicted and he had, I think, 3 years to serve. What was the sentence imposed? I think he got 2 years. I think he got 2 years total. He got 2 years to serve in 2018. 2 years to serve in prison. And Derek Wright says, will you give him some time to turn himself in? The court said, how long would you like? Derek Wright asked for 30 days. The court said 2 weeks or 1 week. And Derek Wright said 2 weeks. Or I guess Antonio said 2 weeks. Derek Wright said 2 weeks. The court said, what date is that? It's the 24th of that month. So he actually, he was let out in 2018 to get his affairs in order before going into prison in 2018, knowing that he had to go to prison. And he did, and he was released, and he turned himself into Rice Street because that was what he said he would do. There's really there's just objectively no flight risk here because he's already proven that he's not going to flee. Because he literally turned himself in, not even for a trial, but to go to prison. When angry and depressed, listen to Case v. Montana. Oh, I could do that. But yeah, this idea that he was a flight risk was always ridiculous. The notion that he was going to flee is ridiculous. He has a bunch of kids in the area. They're in school in Atlanta. I mean, it's nonsense. It's completely bad faith from the state. Oh my goodness. I could keep going too. Should I keep going? Should I watch this Case v. Montana thing? Oh man, people keep tuning in. I have a lot of people watching. This shit is depressed. I know, seriously. I get depressed after a while of reading it. What constitutes probable cause? What else do I want to show? You know what I want to show you guys? I want to show you guys my single favorite part of the indictment. Oh wait, I know. I'll search for mall. There we go. This is my favorite change between the indictment and the reindictment. Not because it's like, legally important or anything, just because of how dumb it is. Okay. So this is the original indictment here. You'll notice they give a direct quote of Young Thug, who allegedly said, because he's a human, and this is how human beings speak to each other, in quotation marks, he says, if you continue to approach, I will shoot you in the face with a gun. Supposedly a direct quote of what Young Thug said. Because again, that's how people speak. And then if you go here, you'll notice that they removed the quotation marks because it obviously wasn't a direct quote. They had just completely made it up. And so they took it out of quotation marks in the re-indictment. This is just, I love this. If you continue to approach, I'll shoot you in the face with a gun. Definitely a thing that he said, for sure. Definitely not completely fabricated. It's fucking stupid. Almost Shakespeare. Yeah, tale told by an idiot. Full of sound and fury, but signifying nothing. You can remember these were these are lyrics. I'm deeply concerned if Antonio has to go to trial again, that I'm going to have to litigate. Antonio Sledge, an Antonio associate of YSL, did pose for a photo released on social media wearing pants. Pants with the letters OTS. With the caption, so not his words, somebody else captioned them. He didn't post them on social media. Somebody just took a picture of him wearing pants. Somebody took a picture of him wearing pants, apparently with the letters OTS on them, with the caption OGs with a green snake emoji that he didn't write, and green heart emoji, which he also didn't write, which is supposedly an overt act in furtherance of the conspiracy. Remember Brian getting so mad about this? Yeah. I think it was. It was just an overt act. I can't remember that. Maybe Steele can help. Oh, no, I'm just kidding. I don't think there's going to be any more litigation on this. I'm sure he could, though. So, you got to be careful about, pant-based offenses. But if he doesn't wear pants, that now you're in trouble too. You can't not wear pants. So I guess he's in trouble for wearing like these pants. Oh, let's talk about another thing. I don't know if I've explained this yet. You guys know the whole 131, 133 thing that I talk about all the time? I don't know if I fully explained all of this. Yes, you can. Pants are always overrated. That's true. How quickly I get booted out of the jury pool this week. Pretty quick. There's one time I was in the jury pool and I knew I was going to get kicked out. And like everyone knew I was going to get kicked out, but it still took them like 3 days to get to the point where they kicked me out. So I just kind of had to sit there for 3 days when everyone knew I was going to get kicked out, but it still took them 3 days before they got to me to kick me out. I was so bitter about that. The lawyers were like, I had said that I was a lawyer, and the lawyers were asking me questions because they knew that the other jurors knew that I was a lawyer. So they were trying to like use me as their mouthpiece to opine on their case to tamper with the jury, like they were being slick. What about the blue jean bandits? You want to look at a Woody thing? Let's look at a Woody thing real quick. Let's look at a really stupid Woody thing. Of the many. Where did I put you? Here we go. This is Mr. Kenneth Copeland. This is the state's memo. They cut and paste this constantly. I have no idea what this font is doing. But this is maybe my favorite. I say that a lot, but I love this. They just left in like the part that you're not supposed to leave in into the Kenneth Copeland brief. State's motion and memorandum of law in support of admission of gang-related evidence to trial. They use this all the time. This is basically the standard motion, but you're supposed to like put stuff in here. But whoever did it, they filed it without putting the important part. See, it says optional section, consider inserting police reports, statements, proffers from gang members, and or secondary sources on gangs. But then they forgot to like do it. And then the footnotes say, this is actually, no, this is the best part, right? So they put in like this like placeholder, but then they have footnote 1. This is where it gets good. It says the state's admittedly non-comprehensive overview of a sampling of the anticipated proof in this case is based in part upon material that is set forth in its response to the discovery requests of the defendants in this case. So, admittedly non-comprehensive is my favorite language because it's literally just nothing. But I guess like technically nothing is non-comprehensive, right? So like it's not wrong. Like if you say non-comprehensive and there's literally nothing, technically correct. So I got to give them credit on that one. And then footnote 2, again, this is a footnote to nothing. It says the state is making a collective reference here and acknowledges that all of the defendants may not have provided statements to law enforcement, and that the content, extent, and nature of this and other evidence might vary from defendant to defendant. The state further acknowledges that a Jackson v. Deno hearing will be necessary prior to the admission of any defendant's formal statement to law enforcement at trial. And again, this is citing just to nothing at all. It's right here. So yeah, missing the whole purpose of a template. I actually talked about one of these footnotes before. What's this guy's name? It's one of the really long ones. I don't know what this font's doing here. They haven't changed. I tweeted about this. There's something called the Macaroni Gang, aka the Miami Boys, and I just didn't believe that. I've read this thing so many fucking. Oh, here it is. I highlighted it. So I noticed that all of this is really outdated. Some of these links are broken because it's been so long. But let's see here, footnote 10. I don't know quite why they're citing to anything because they're just quoting something. But it says the state of Georgia is in a state of crisis. Bad writing. Don't use state twice in a row. Which has been caused by violent criminal street gangs whose members threaten, terrorize, and commit a multitude of crimes against the peaceful citizens of their neighborhoods, constituting clear and present danger, seeking the eradication of criminal activity by criminal street gangs. And one of the things they cite to is this guy right here. Brian Ludke. That's not his name. They spelled his name wrong. The Duct Tape Gang. Duct Tape Dave. This guy right here. And I saw that it was a California law review, California Western, I think. And so I was curious because I read the articles, which I'm sure nobody ever does. And I was like, I looked at it and I kind of realized that it didn't really it was kind of like anti-gang act stuff. But the point of the article was that you can't have, he actually references Malibu's Most Wanted in the article. It's really funny, actually. twice, I think. He's basically, there was a gang in Malibu, but they wouldn't identify them as a gang because they were the children of like rich people, even though they were like explicitly referring to themselves as a gang. But his point was that you can't have inequitable gang enforcement, and you can't use law enforcement as a way to combat gangs because it'll end up being inequitable and you'll just perpetuate, gangs by destabilizing communities. And that was essentially the point of the article. And I was like, that's weird. So I actually emailed this guy because he works down the street from me. And I sent him this motion, and I was like, hey, bro, did you ever know that they were citing your article like this? And he was like, no, that's wild. And I sent him, and I was like, do you think that your article supports the proposition they cite it for? And he said no. So I reached out directly to the source, and he said no, it does not support the proposition they support it for. So I asked Brian personally, and he said that they're wrong. So if that's not good enough for you, I don't know what is. But I thought I told that story on here before. But yeah, I reached out to him personally, and he said that their pants are on fire. I think that one isn't broken. This one might not work. Yeah, so the top link, if you go to it, you get this page right here. It says the source given that they're citing to, it says page not found. So, they should probably update their citations at some point. It is what it is. I don't know. Maybe they will. Maybe they won't. We'll see how it goes. Honestly, I think this one works, but I'm not sure. Nope, this one doesn't work either. So that link is also broken. That's what happens when you just keep using the same template for like 10 years without updating it. You just get a bunch of broken links and citations that are wrong. I wonder if they cite to Carlson in here. No Carlson. That's amazing. I completely forgot where I was. I'm on a rant now. Oh yeah, I was going to explain to you guys. So I've gone into the 131, 133 thing, but I still haven't explained everything. Because the 131 thing, it goes deeper. Oh man, that was the one I was going to show you guys before I went on my tangent and completely lost my mind. Because I'm completely all over the place right now. Let's look at, I forgot to go into the Jimmy Winfrey thing. That has the worst footnote I've ever read. Where are you? I'm going to do a video on this brief at some point. Here we are. Here we are. This is the worst citation that has ever been made. Okay, statements of facts and proceedings in the court below. By participating in the Bloods gang-motivated shooting in this case, Winfrey sought to impose his will on busloads of victims, an interstate highway in the state of Georgia writ large. He sought to impose his will on an interstate. That's an odd thing. Show it. Okay, fine. If you guys insist. Here we go. Here we go. All right. I'll show the little Wheezy footnote just because I love it so much. You see this? Here we go. By participating in the Bloods gang motivated shooting in this case, Winfrey sought to impose his will on busloads of victims. I think it's just a busload. It's just one bus, right? Thanks, guys. If I mess up the screen thing, definitely yell at me. Because I'm going to forget. On busloads of victims in interstate highway in the state of Georgia writ large. The entire state, he tried to impose his will on literally the entire state of Georgia. But forget it. remaining consistent in his domineering conduct and nearing niobic levels on appeal. And then, despite saying niobic, they then go down to explain their own reference. They need to define their own word because they're not confident enough to just use the word. If you need to define your own word because you know the reader isn't going to get it, just don't use it. Okay, in classical mythology, Niobe claimed to be superior to the gods. This is dramatic. Reference to Niobe can be found in Greek bard Homer's Iliad and later in the Roman poet Ovid's Metamorphoses. The gods exacted a heavy penalty on Niobe for her insolence. You silly little person. Oh my God. Winfrey attempts to place himself above Georgia appellate precedent, even the opinions which Winfrey himself cites, which is emphatically antagonistic to his appeal. Winfrey meets out these self-inflicted wounds. I don't know what that's. With hyperbolic harangues laced with inapposite case law and disparate dicta. That's not what disparate means, but that's okay. The gaping holes in Winfrey's briefing are tantamount to an admission that there's no support for his appeal. Man, it'd be really embarrassing if they lose, wouldn't it? It'd be really embarrassing if they got their cheeks clapped. But they did. They did lose. They did lose. It was fantastic. It was beautiful. Everything about it was lovely. I'll show the brief. You'll notice this. I mentioned Carl Winchester earlier, actually. This is Carlson of Carlson on Carlson on Carlson on Carlson on Carlson on evidence. Matthew Winchester, who represents Darren Mills, who I mentioned earlier. And I've read this footnote 800 times because I love it so much. Appellate Jimmy Winfrey pled guilty to 6 counts of violating Georgia's Street Gang Terrorism Prevention Act in condition with a drive-by shooting of rapper Lil Wayne's tour bus on Interstate 75. Lil Wayne, also known as Lil Weezy, Lil Weasel, Lil Full Clip, Young Wheezy, Wheezy F Baby, Wheezy F Crazy, Wizzy Fizzy, Mr. Coach Carter, and Mr. Shoot 'Em Down. His given name is Dwayne Michael Carter Jr. You guys want to see something funny? Let's look at something funny. I get to pull up the Georgia. Actually, I'll just show you guys how to do this. I've shown this before, but in case you guys are interested, it never hurts to show again. Actually, let's spend some time looking through some of the data. Some of the purchase orders. Ooh, that hasn't been updated in a while. Maybe the vendor payments are more recent. Vendor pay. Let's see if this is more recent. Ooh, this is more recent. Perfect. So I'm going to download this. Once I get it formatted, I'll show you. It's like 238,000 rows, so it'll take a second to format it. But this thing is where all the good stuff happens. This is where all the dirt can be found. Hades 2. Oh, yeah, that's good. How much mileage has Fulton County made off Halloween bus street? Didn't even happen in Fulton County, too. Happens when you blood up time on YouTube. Yeah, that's totally true. All right. So I'm going to show you guys my screen so you can follow along. I just need to get this sorted real quick so it kind of makes sense. There we go. I just showed you a sneak preview of the Pat Labatt project I have going. I'll show you a second later. So this is all of the vendor payments made by Fulton County over the past 4 years, I guess, like 238,000 rows long. So we're not going to look at all of those, but you can just filter these and look at, ooh, it's going to take a second, department, district attorney's office. Okay. Ooh, actually, there's a better way to do this. I know what I'm going to do. How do I want to do this? So this, yeah, I'll just do it this way. This is fine. I don't need to do the whole thing. Not you. Not you either. Not you. Maybe it's one of these. Man, this is totally ruining my fun right now. So what I want to do is show you a bunch of expenditures, but it's not doing what I want. This will be a little easier. Not Eric Carlson. Here we go. There we go. This is better. Let me see if you guys can see this. Oh, there we are. All right, switch windows here real quick. You guys will be able to see. There we go. This. So Michael Carlson worked for the Fulton County DA's office. I'll hide some of these. But they spent $50,666 on getting this book, Carlson on Evidence. So they spent $50,000 on just that book. Ooh. This is a smaller file, so I can make this, I can format through this a lot faster. We're going to look at some of the expenditures of the Fulton County District Attorney's Office. Sneeze guard desk shields, no. Here we go. Oh man, this is the old one. That's okay. I want to look at some of the furniture they have. Because some of the desks that they have are just super expensive. There we go. Office desk group with storage espresso, $3,800. You guys can't see this at all, can you? I can hide some of this stuff. Hide this one. Carmen Miller time. Yeah, pretty much. So Aldesk with Hudson File. Let me see. Paid $3,700 for it. This is $1,700 desk, $1,700 desk, $2,000 table, $2,000 desk. $3,500 suite. Let me see. Another $3,800 desks. That's something else. Okay, I'm gonna show you guys. This is gonna be embarrassing because of how much time I spent on this when I shouldn't have. But this is my latest project that I'm working on. This is Pat Labatt's training expenditures. Training and travel expenditures. Since I think I went through the fourth quarter of 2023. And some of these are pretty wild. So this is the person that traveled. I'll make this smaller. And remember, this is the jail budget. So this is like instead of spending money on doors that lock in the jail, which is a pretty important part. So these actually, some of these, like this is one conference, and there's actually 2 entries for it, which is weird. But this is $5,000 on one conference. Ooh, you guys can't quite see that. I'll hide these. We don't really need these. There we go. That's better, I think. So these are the yes. These are various travel expenses. So this is Labatt. This is the sheriff. $1,000 for this one, which, I guess is whatever. But what really gets interesting is when you start to do it by conference. So for instance, this one here, the 2023 National Sheriff Association Annual Conference. This is just one conference here. And you'll see that totals $12,000. $12,306 just for that one conference. Oh wait, it's actually more than that. I skipped one because it's also this one. See, there's this executive protection. So when Pat Labatt travels places, sometimes he has this guy, Willie Wiggins, travel with him because he needs protection. Even though I'm sure this isn't in Atlanta, and it's literally a bunch of sheriffs. So I don't think anyone's going to recognize him or care about him. But they spent $14,000 just on this one conference. And if you go through any couples going away on these conferences, I wouldn't be surprised. I mean, I don't know enough to say. But here's another one. The CSCJ Summer Conference is $4,400. Sometimes he has multiple, actually, James. Let me show you. Let me see if I can find a good example. Here we go. So on this one, this is the 2024 National Sheriff Association conference, winter conference, which is all of these here. he actually had, well, this is two people, but he had two people. He had two bodyguards at the 2024 NSA Winter Conference. Which is located in, let me see, that was in Washington, D.C. I'm pretty sure he's not one of the 1,000 most important people in Washington, D.C. when he is there, but he has two different bodyguards. So again, just the 2024 Winter Conference totals $16,000 in travel expenditures. And again, you have to ask yourself, how many door hinges can you replace for $16,000? I'm not saying $16,000 is enough to fix Rice Street, but you can do a lot of stuff with $16,000. You really can. Especially when the issues in question are, you know, the doors are falling off. The doors don't lock. You can fix a lot of stuff with that amount of money. Let's see. I have my suspicions about these numbers, but I'm not going to ask questions about the dogs. And look, they're traveling to see if they can put people from Rice Street into these other jails, and it's like all of these people are getting, first of all, different amounts of reimbursements. But just to visit another jail, this is $5,200. Just to visit another jail. I have no idea why that would be necessary. $5,300 just in visiting other jails. And you see, it's just, there's always multiple people for all these conferences. Another $2,500. MCSA policy conference is almost $11,000. And some of these might actually be duplicates. Like, I don't know if the 24 NSA conference is the annual conference or the winter conference. Probably the annual one. But it's another $4,000. The Noble conference, like $3,500. Oh, wait, no, it's more than that. It's about $14,000. The state legislature decides how much. Yeah, but these aren't even the reimbursements. These are just like visiting the jail. But yeah, some of these are wild. Like this conference right here, the 2024 IACP conference is a $2,800 reimbursement. Oh, no, that's too many. Yeah. This year, the 6,000. And I kind of had to format all this stuff to make it work. 2023 NSA annual conference, $12,000. And you see there are actually two entries for some of these people. Like Curtis Clark is on here twice. For $1,800 and $700. Let us see your hinges. Yeah, exactly. 2023 Noble Conference is another $12,000. And then we have two entries for executive protection, $2,100. And yeah, I mean, this guy has 3 different reimbursement amounts. Like this guy alone has $4,600 in reimbursements for conferences. Oh, you guys can't quite see that. Yeah, you guys can more or less see it. So I have some questions about some of these numbers. I haven't gone all the way back. I've only gone back to neither secretaries. Yeah, I have some questions about that. But That's a completely unrelated thing. I don't even know how I got on this. When you first opened this, I saw an entry for a baptism. Let me check. Oh, Baptiste. The gang expert conferences. Yeah, seriously. No, not you. Not Bap Gang. We had a demo. We did. All right, I'm going to start winding down, but I do want to show a few more things. This is a press release from the Fulton County Sheriff's Department, Sheriff's Office. So this relates to drones, which is a real thing, a real issue. Oh, goodness. Okay. 2 men, Richard Redding and Jeffrey Jenkins, alliteration, nice, have been arrested in connection with a suspected attempt to deliver contraband to the Fulton County Jail, using a drone. They were being held at the Fulton County Jail without bond. Of course they are. On the evening of April 1st, 2025, investigators received a tip of a drone flying in the vicinity of the jail. Investigators identified a vehicle parked at a dead-end residential street adjacent to the jail, yes, McChicken, that appeared to be out of place. A search warrant executed on the vehicle led to the discovery of a drone, complete with controller and case, a large quantity of marijuana, multiple pills, including suspected oxycodone, 48 packs of cigarettes, over 100 loose cigarettes, paracord, plastic packaging, and 9 cell phones. As a result, the 2 men in the vehicle arrested and charged with the following. I'm not going to read through all of these. I kind of want to, because there's probably something wrong in here. But here we go. Last weekend, a package containing McDonald's chicken sandwiches and suspected oxycodone was found tangled in the concertina wire on the jail's perimeter, which makes me wonder, was there a drone involved, or did somebody just try to throw it over the thing? Because that to me seems like somebody just tried to throw the package over the wall, right? Because if you had a drone, you probably wouldn't drop it onto the wire. It feels like somebody just tried to yeet the McChicken sandwiches over the wire. That's just me, though. I'm not an expert. I'm not a gang expert. I mean, I probably am compared to them, but if you can't even get the stuff over the wire, I don't know if that's a drone. We're combating technology with technology alongside good old-fashioned detective work. I want to commend the teamwork and communication of all investigators and officers. We remain vigilant in investigating contraband smuggling operations. To prevent these dangerous items entering the jail, we'll continue to pursue those who threaten the safety and security of our facilities. You could become a gang expert. I could become a gang expert. Ooh, they don't have anything right now. Ooh. I'm also not going to tell you guys because, you know, I don't want to get myself in trouble. But the Georgia Gang Investigators Association is very bad with data security. They kind of dox all of their members. That should be a private list, a secure list. But they are really not good at the whole data security thing. Drones are easier to jam. Yeah, they did spend some money on drone, anti-drone drones. Oh man. You guys are right. I am like all over the place. I do have too much built up in my brain. Ever sure you guys count 52? Or 53? Let's do 53 since that has a plat out. This is also a 133 thing. This is one of the quays. Just slide over a little bit. So this is the original one, right? And this is almost correct. It says possess or have within arm's reach. It should just be have within arm's reach. But that's like almost right. Again, this is the YSL indictment. So this part in red here is all, you need all that stuff. And then in the second one, they took it out. Oh yeah, I need to look at that Fourth Circuit thing, right? Can you find a link to that Fourth Circuit thing? The Case versus Montana one, if you have it? Whatever, yeah. So they took it out here in the reindictment. Then to compare that with like count 30, which is the one that I have to obsess over. This is also an issue with 133. But here it's a completely different mistake. It's going from 131 to 133. So it's the same thing. The Case versus, okay. I should be able to find it. What was the name? It was Case versus Montana or something? Ooh, is this, the Supreme Court, the oral argument. Okay, I have it here. Finish case. So that looks like it's an hour long. I can do it tomorrow or something. Yeah, sorry, I was looking at it. Yeah, I think I'll have to do that in a separate one. I'll definitely do it though. It sounds interesting. Okay, M6. Okay, I got it. Okay. Yeah, I'll do. I think I'll do that tomorrow. I'm sorry, Karen. So I'm just gonna finish this up. I've been going for like 3 hours. I just wanted to show that. So this isn't the YSL case. There were multiple different ways. There were multiple different mistakes made. Involving this charge. $131 and 133. So it wasn't just one mistake, it was multiple different mistakes that had different results, multiple different changes, affirmative changes. Like for instance, this ended up getting dismissed. But it's not just these, it's also I don't think it's this one in the overt acts. I think this one might be. Yeah, this is an example. Oh wait, no, not this one. These were changed. But It's over Act 50. Oh, wait, hold on. There you go. You should be a moderator now. There we go. So they also changed this one here, Overt Act 50, from 131 to 133. Trontavious Stevens. There are a few more. Oh yeah, I think 55 was too. '54, 55. That's right. So this one, they made a mistake, in quotes, on this one, on 54, but right below it, they actually didn't change it. See, so Shannon, who had a lawyer when this was done, they didn't change his, but Trontavious Stevens, they did change. See, is 133. They changed it from 131 to 133 for tick, but then just right below it, they didn't change it. See, that part was always strange to me. 3 job interviews this week, only one of them. Yeah, I need to start doing that too, actually. I think I should go back to a law firm at this point. Now that I'm starting to hopefully wrap up the Georgia stuff that I'm working on. Hopefully they don't make me feel too dirty, or like a good dirty, you know. But if you look through, there are actually a lot of these mistakes that kind of suggest that it wasn't a mistake, because let me see, 98. You'll see that there are these conforming changes throughout the 2 versions of the indictment, and they all kind of work together to end up with a result that on these counts down here, 63. All right, that's right. 63, 64, and 65. They can get these increased charges while being consistent. I don't know. I didn't explain that very well. Ugh, starting to lose steam. Let's see if there's anything. Yeah. I'm worn out. Who's the clock? Yeah, seriously. I think I'm gonna call it a night. Oh man. Did you get to see the pup? Yeah. Let me see if I can find him. I'll be right back. Here he is. Okay, here he is. She's a little shaggy right now. He like he's really into like grown women, not dogs. He'll just like go up and start like sniffing women and like jumping on them. He has no interest in like guys. Doesn't care about guys at all. Doesn't care about dogs at all. He just doesn't like dogs. He doesn't seem to realize that he is a dog. But I'll like turn around and he'll just be like with his paws up. Get me in trouble. Alex, man. Yeah, he's a good boy. He started hiding from me when he can tell when he's about to be taken outside because he will he knows that if I'm like putting my shoes on, there's a chance he's going outside, so he'll just run and hide somewhere. Age of withdrawals without seeing. Yeah, no, I was missing you guys too. I was just like trying to write the sledge thing, and it was driving me crazy. He doesn't like the outside. He likes being outside. He doesn't like going outside. So, like, from the front door of my apartment to the outside, he doesn't like. But, like, once he's physically outside, he likes that. So it's like a really difficult 6 seconds. He's very stressed out for like 6 or 7 seconds until we get outside. But once he's outside, he's good. Also, same, yeah. Yeah, I guess I gotta do that case thing tomorrow. So I should be able to stream tomorrow. I don't think that'll be a problem. I'll probably like think of stuff that I forgot from today that I want to talk about. I'll probably do too. But yeah, I think I'm gonna call it a night. Thanks everybody. Thanks for there's that one donation. I can't remember who it was, but I want to forget. Where are you? It's gone now. I can look it up. But yeah, I'll let you guys know what it is. Thanks everybody. Have a good night. Remember to ask for likes before you end the stream. Yeah, if you could like, I think most of you would probably subscribe, but if you could like the video, that'd be appreciated. I'll take this guy outside. It was from Amber. Oh yeah, that's right. Thank you, Amber. Thanks everybody. Have a good night.